Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give their attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court. Welcome to the November case call. For those of you who have not been with us recently or ever, we provide the first 5 minutes in the calendar cases to you free of questioning, and it is my advice to you that you use those first 5 minutes to explain the outcome determinative issues. We have read your briefs. We don't need a regurgitation of them, so with that, I'll call the first case. Landin versus Healthsource of Saginaw, Inc.
May it please the court, Mr. Chief Justice, Justices. My name is Richard Warren, and I'm here on behalf of the appellant, Healthsource Saginaw. Thank you all for accepting our application. This case is obviously of great importance to our client, but it's also critical to the direction of employment law in Michigan and the health of the at-will employment doctrine in this state. The court has asked us to address two key issues, so I'll get right to the point. First, the court has asked us to answer the question of whether a plaintiff may maintain a wrongful discharge public policy claim under the Public Health Code, specifically section MCL 333-20176A, and to address the related question of whether the Whistleblowers Protection Act provides the exclusive remedy for a claim of wrongful discharge under that statute, the Public Health Code. The answer is that a plaintiff, and this plaintiff, may not maintain a public policy wrongful discharge claim under the Public Health Code. The legislature has already spoken on this point, and it is determined that the only remedy available to somebody in that situation is to assert a whistleblower claim. We know this is true because the legislature took great pains to specifically incorporate the WPA into the Public Health Code as a remedy for someone who's terminated in response to reporting malpractice or a violation of the code, period. The problem for plaintiff is that courts are not permitted to graft on or add a common law remedy or any remedy once the legislature has spoken on that point. This is exactly what the Court of Appeals has done in this case, and it's the reason why its published opinion is in dire need of correction. The opinion runs absolutely contrary to Justice Scalia's stabilizing canon number 52 that says a statute will be construed to alter the common law only where the disposition is clear. In other words, under the Dudowitz decision from this court, a claimant cannot have a public policy wrongful discharge claim in the shadow of the Whistleblowers Protection Act. If the Court of Appeals' opinion is left uncorrected, and I emphasize again it's published, we might very well see a counterpart wrongful discharge public policy claim along with every Elliott Larson claim, every Persons with Disabilities Civil Rights Act claim, and every whistleblower claim also. Now, my opponent is a talented lawyer, and undoubtedly he will get up here and discuss the facts of the case. And even if all of what he says is true, none of that matters because his plaintiff had one cause of action and one alone that he didn't plead and couldn't plead, the Whistleblowers Protection Act, not a public policy wrongful discharge claim. The plaintiff would have been in a better place if the legislature had never added in the Whistleblower Protection Act as an exclusive remedy. He would have been able to assert a public policy claim like in Pompey versus General Motors, but that's not the case here. He had his remedy. Through his voluntary actions, he failed to take advantage of it. And that doesn't entitle him to a public policy wrongful discharge claim as a consolation prize. No Michigan Supreme Court case says that, and the legislature didn't say that. The Court of Appeals essentially has judicially amended the Public Health Code to add in a new remedy where only one existed and only one was picked by the legislature, and that can't be allowed to stand. For the reasons outlined in our brief, the Court of Appeals decision left undisturbed will send a signal to the employment bar in Michigan that Toussaint-like claims are alive and well, that they've been resurrected. And from experience, I can say it's a signal that the plaintiff's bar and the employment bar will likely not miss. That will end about 20, 30 years of this court's efforts to contain Toussaint and claims like it. One fact we should not lose sight of is that in this state, employment relationships are always at will, unless a termination or an action offends a statute, unless it offends a contract, or unless it offends public policy. We don't have any of those three circumstances at issue here. The termination at issue here just doesn't fall into any of those three categories. The Shadolsky decision provides a very narrow exception for public policy wrongful discharge claims, but to do so, a claimant has to fall within one of those three different baskets. We already know that the second basket isn't an issue here because plaintiff never claimed that he was terminated for refusing to violate the law. So all we have is the first and the third Shadolsky exceptions. Number one, where an explicit legislative statement prohibits discharge for exercising a duty. And three, where an employee is terminated because they've acted in accordance or exercised a right conferred by a well-established legislative enactment. Neither of those exceptions applies here. The first exception doesn't apply because
Why doesn't the third apply?
the third does not apply because, number one, as the Court of Appeals has found, and plaintiff has also indicated, he did not act pursuant to that statute. Plaintiff has indicated that he did not report a violation of the public health code. And under Shadolsky,
He didn't report to the department. He did report to his employer.
that's correct, Your Honor.
Here's my conceptual problem. It seems to me that we have a developed jurisprudence for when the court may imply a remedy where the legislature has failed to do so. And that stands in stark contrast and in tension with the Such-Oldusky freestanding common law remedy. And I'm struggling to figure out how to reconcile those, because on the one hand, on the implied remedy side, we are very respectful of the work of the legislature, but in Such-Oldusky, we just sort of said, well, we're making something up that is perhaps in contradistinction to what the legislature has determined here. And in this particular case, for example, there are two provisions that seem to be in play. The one where the Whistleblowers Act is explicitly listed, and then there's this other section that seems to be a legislative licensing remedy that's directed at the licensee of the hospital. No apparent civil remedy there, but it does talk about, the licensee being prohibited from doing certain things to the employee, as appears to have been alleged here. So my question is, why doesn't Such-Oldusky, why isn't that your problem? If we were under the implied remedy strand of our jurisprudence, you'd be home free. But Such-Oldusky introduces this other variable, and I'm having difficulty figuring out how to reconcile them.
I can address that, Your Honor. So that the licensing portion of the statute doesn't allow someone to make out a prong 3 Such-Oldusky claim because it's not directed at conferring employment rights. Licensing is not the same as an employment right. And
Well, it says, doesn't it say you shall not discharge?
I know which section
That
you're referring
statutory
to.
provision?
You're correct, Your Honor.
Well, it sounds to me like it's addressed to this very situation where the employer retaliatory, at least allegedly, discharged for the report.
I agree with you. That section does mention employment rights. The problem for plaintiff is that he already has the Whistleblower Protection Act as a remedy. That's the one that the
Not for
legislature...
that provision. There is no remedy, there is no civil cause of action for the violation of what I've called the licensing sanction provision. That's designed to ensure that the department enforces the employment rights of people who make complaints about things that go on in hospitals.
You're correct, but there is that separate section. It's the .0080 section that references the Whistleblower Protection Act expressly. If someone makes a complaint, a violation of the code or other violation or complaint, then their remedy is the Whistleblower Protection Act.
Let me read from Sochildowski. In addition, the courts have found implied a prohibition against retaliatory discharges when the reason for the discharge was the employee's exercise of a right conferred by a well-established legislative enactment. The licensing provision here, the licensing sanction provision, sounds to me a lot like that, does it not?
It does, but again, we're talking about one statute interpreted as a whole that the Whistleblower Protection Act has been incorporated into as a remedy. And I'll distinguish that by pointing to the Pompey versus General Motors case. That was a case under the Fair Employment Practices Act where, without question, that statute said you have a right to be free from race discrimination in employment, but it only provided for administrative remedies. And there the court correctly said, you do not have a right to sue for money damages or injunctive relief. Therefore, there is no remedy and you can have a public policy claim. We don't have that here in this case because the very statute plaintiff is identifying as the basis for his claim provides him with a Whistleblower Protection Act claim. And under the case law, that's his sole and exclusive remedy. I think everybody agrees that at common law, there was no right to be free of termination for this action, nothing at all. That right was only created with the Whistleblower Protection Act.
Does the Whistleblower Act provide a remedy to a plaintiff who reports to the hospital? The hospital's not a public body, right?
You're correct. So I agree with you, Justice, that that would not allow a plaintiff to state a prima facie Whistleblower Protection Act claim because he didn't report to a public body. But that is a different question than whether the Whistleblower Protection Act allows for a remedy in general. I have not found any Supreme Court decision that has said that where an individual can't state a prima facie claim under the WPA in his or her circumstances, that's when they get a public policy wrongful discharge claim. There is a stark, I'm sorry, Justice.
No, it's just hard for me to understand how we should think of the WPA as the exclusive remedy if it doesn't provide a remedy to this plaintiff. In other words, as I understand your position, it is that the plaintiff should have then gone forward and reported to a public body?
That's correct, Your Honor.
The problem I have with that is the claim that the plaintiff has is different than that. He's not saying that he was fired because he reported to a public body. He's saying he fired because he reported what he believed to be malpractice to his employer. So wouldn't it be strange for us to say, no, what you need to do is report to a public body, and then instead of claiming what you're claiming, you should make a different claim, even though you may not believe that's what happened, and claim you were fired because you reported to a public body. Isn't this all sort of a strange construct that that's what this is the message we would be sending to the plaintiff? You have to actually set your claim up in a way that's different than you actually believe it to have happened and claim it a different way so that you can fit within the confines of the protection that's offered?
I can address your concern, Your Honor. I think if you look back at Dudowitz, that does not say if someone can state a prima facie claim and only if they can state a prima facie claim, the WPAs are exclusive remedy. What it says is that the existence of a remedy...
Excuse me, I'm locking you in now.
This is when it gets really fun.
Go ahead, I'm sorry.
Okay, it looks like the windows are down now.
That's what you think. Go ahead.
What Dudowitz says is that the existence of a remedy provided by the legislature is determinative of whether a public policy claim can exist. The existence, not whether it's viable for this particular plaintiff, the existence alone. And I think that's the controlling principle that guides the determination of this case.
But I'm not sure that quite answers Justice Viviano's question. I mean, I think what he's saying is the Whistleblower Protection Act isn't actually a remedy for someone who doesn't think he was fired for reporting to a public body. He thinks he was fired for reporting to his hospital. So whistleblower would never, I guess he could just go complain to a public body and then hope that that claim also fit because that remedy is there. But what if he has a different claim for which that isn't responsive?
I understand the concern about whether in this person's situation he has a remedy under the WPA or not. But if we go down that road, then we're letting an outcome determinative question be answered by the person who's going to assert the claim. And I think the implications of that potentially could be disastrous for the state.
Doesn't Sochadewski, though, support us going down that road?
It supports you going down that road, Justice, only if he can state out a claim and identify a statute that's directed at conferring employment rights that doesn't already provide a general remedy.
That takes us back to Justice Viviano's point.
And again, the point is, the only situation in which this Supreme Court has ever recognized a public policy wrongful termination claim has been, like in the Svenko case, the workers' compensation case, or the Fair Employment Practices case, Pompey versus General Motors, where there unquestionably is no remedy at all, no cause of action, no avenue for monetary relief or for injunctive relief.
Counsel, good morning. I have a question for you based
sir.
on what you just said. You said it would be disastrous for the state, but don't you think it could be disastrous for the state if you go the other way? If there isn't a meaningful remedy for a plaintiff in this situation, wouldn't you be concerned that, since we're discussing public policy, could be more detrimental than your argument?
I can address that, Your Honor. I think it's a very valid concern, and I wholeheartedly agree that on matters of public health, we want people reporting what they think is wrong in the workplace. We want that to happen. But I would argue that the Whistleblower Protection Act is a superior remedy to a public policy wrongful termination claim for the following reason. If you look at why the WPA was originally enacted, it was to prevent what happened in the 70s with the contamination of livestock feed, and to remove barriers for people to report to the public so things like this can get addressed. If we allow the plaintiff, someone in this
But
case...
counsel, isn't the only impact then a $10,000 administrative fine? I mean, under your argument, under your scenario, what about the individual who comes forth and then suffers damages or loss of employment or the other injurious things that would come of it? I mean, isn't that a bigger concern? And how do you feel that public policy is benefited by just a $10,000 administrative fine that would be alleged, that would be assessed?
I can address that, Your Honor. I think the public would benefit wholeheartedly for someone proceeding under the Whistleblower Protection Act, because that requires a more immediate filing of a claim, a 90-day statute of limitations, whereas a public policy claim does not. You could surface that claim 2 or 3 years later, and I think the legislature's intent when they originally passed it was they wanted these issues of tremendous public importance to be brought to the public's attention sooner rather than later, at a time period where they could be corrected and addressed. And the WPA does provide individuals with monetary relief. They can sue for compensatory damages, future damages, attorney's fees, as well as emotional distress.
Counsel, again, we're trying to figure out how to approach this. Justice Viviano says, is it a remedy if this particularized individual chooses not to or cannot avail himself of that remedy? Your answer to that question is what?
Yes, it is a remedy. It is a remedy, and the legislature has provided
The
one.
focus of the court should be on what issue? Whether this particular plaintiff can avail themselves of the legislative remedy or what?
The focus of the court should be on whether the legislature has incorporated a private cause of action into that statute.
Whether a particularized individual can avail himself of that remedy or not.
My point is that the focus of the court should be on whether the legislature has generally provided
Right.
to the public.
I don't think I'm talking at cross purpose. I'm just trying to make sure that the court should look to determine whether there is a civil remedy provided, irrespective of whether a particularized plaintiff can avail themselves of that.
That's
Is that your
correct.
position?
Yes, Your Honor.
Now, why, that seems a sensible proposition, and that's exactly the proposition we refer to when we're looking at implied remedies. If the legislature has got a remedy, the fact that we'd like it to be something else is irrelevant. We respect the legislative determination. Except, Sochadewski doesn't follow that logic. So again, I'm asking you to help me to reconcile how we deal with this discordant 2 lines of our jurisprudence when in Sochadewski we say, in addition, the courts have found implied a prohibition prohibition on retaliatory discharges when the reason for a discharge was the employee's exercise of a right conferred by a well-established legislative enactment. We have the well-established legislative enactment that prohibits retaliatory conduct for the reporting of hospital malpractice negligence. That's the second regulatory section. So I'm struggling here to have you explain to me why Suchel-Dusky isn't an exception to the well-established line of precedent that says we will respect the remedy the legislature provides, except in this circumstance.
And I think the response to that is that prong 3 point in Shadalski is naturally constrained by whether the legislature already provides a remedy, the point that I just made. And if the legislature does provide a remedy, prong 3 claim or not, that remedy is exclusive.
Is your point that our jurisprudence on implied civil remedies somehow trumps or should inform when Suchel-Dusky is alive?
I think it absolutely should inform what is a proper Shadalski claim
Have we
or
ever
not.
have we ever said that?
I'm sorry?
Have we ever said, that's a construction, that's a limiting construction in Suchel-Dusky. Has anybody ever suggested that in the jurisprudence?
I have not found that express suggestion, but I think it certainly is implied in Dudowitz when it says that the existence of a legislative provided remedy is determinative of whether you have a public policy claim. It's at page 79 of Dudowitz.
Counsel, since you referenced Dudowitz, I'm having difficulty squaring your position, which I understand to mean that if there's a civil remedy available generally under the statute, even if it doesn't necessarily apply to this plaintiff, then there would be no public policy claim. But in Dudowitz, the analysis ends up, our court concluded, and I'm quoting, because the WPA provides relief to Dudowitz for reporting his fellow employees' illegal activity, his public policy claim is not sustainable. So it appears the court had a much more sort of personalized view of whether the plaintiff before the court had a remedy under the WPA. That's different than the position you're taking today, is it not?
I agree with that. So that's at page 80 of Dudowitz. After page 79 mentions the existence of a remedy is determinative. But when I read Dudowitz, what Dudowitz does not say at page 80 is the proposition that plaintiff wants it to say, and that is if someone can't make out a prima facie Whistleblower Protection Act claim, then they do have a public policy wrongful termination claim.
Well, there's a sentence before the one that Justice Viviano read, is there not? A public policy claim, this is from Dudowitz, is sustainable then only where there's also not an applicable statutory prohibition against the discharge and retaliation for the conduct at issue. That then puts into play what is an applicable statutory prohibition. In what sense is the WPA remedy, which the plaintiff here did not exercise, could have but didn't, in what sense is that an applicable statutory prohibition against discharge?
And I think I would answer that by reference to Dudowitz itself. Dudowitz did not define what it meant by applicable. I've looked at that case many times.
Isn't that what we're trying to figure out now?
Absolutely, but I think it has to be read under the umbrella of its prior statement on page 79 that the existence of a remedy provided by the legislature is determinative of whether there can be a public policy claim. The court could have chosen the words, the viability of a whistleblower claim is determinative, but it didn't say that, it said the existence.
But it didn't say, I don't mean to interrupt, but it didn't say this, the existence of a specific prohibition, the sentence you're relating to, against retaliatory discharge more broadly. It said a specific prohibition in the WPA, so it lodges it has to be lodged in the WPA, does it not? Isn't it? So we have to look at the WPA and see if there's a specific prohibition as it relates to this plaintiff's cause of action, do we not? That's where I'm having difficulty.
I think it's a valid question, I can address it, and I think this is certainly, Justice, you had a question as well.
No, go ahead.
And I think this is certainly not binding, but Justice Zara articulated this in his Court of Appeals
Oh,
opinion.
you're losing now.
in the Mount Clemens Parent versus Mount Clemens General Hospital decision, it said, look, the reason why we can't have a public policy claim under these circumstances is because the legislature, by incorporating the WPA, sent its intent and its signal that it wanted people to report publicly to have
Counsel-
these issues addressed.
Counsel, isn't it true that on this fact pattern alleged by the plaintiff, he could have reported this to the department and thereby established a WPA claim?
Absolutely, Your Honor. He could have.
So that it is a viable remedy, it just wasn't exercised by this particular plaintiff, is that correct?
That's correct, by his voluntary actions. He could have
Right.
picked up a phone.
So let me ask this question. I think it's a simpler hypothetical, but I'd like to know whether it's any different. So we have a well-established public policy in this state against race discrimination in employment. We have the Elliott-Larsen Act that has a 3-year statute of limitations. If we had a plaintiff who was discharged from employment because of his race and then filed a claim under Elliott-Larsen 3 years and a day after the incident, would he have a public policy wrongful discharge claim?
Absolutely not. And
And is that case any different than this case?
it's not any different. And I would argue that the danger of this Court of Appeals opinion is that we could see claims just like Justice Larson identified.
You're under 5 minutes. Do you wish to reserve?
I
any
wish to
time?
reserve your right. Thank you.
I know, I'll wait till he comes.
Okay.
May it please the court, on behalf of the plaintiff appellee Roberto Landin and our amicus, the 10,000-person strong Michigan Nurses Association, I am Mandel Allwild. The British philosopher Edward Burke, a supporter of the American Revolution, once declared, "Justice itself is the great standing of policy of civilized society. Any departure from it under any circumstance lies under the suspicion of being no policy at all." Michigan, as virtually every state in the Union, recognizes a public policy exception to the at-will employment doctrine. That is, some causes of termination are so heinous, so against the public interest, is they must be prohibited. This case represents the quintessential public policy case. Your Honors, if this case is not a public policy case, I can't frankly imagine what would be. We have a person who reports that a nurse was incompetent, negligent, precipitated the death of a patient, and is a danger to the other patients in this hospital. We have a hospital who then retaliates and terminates that person. And by the way, if we don't have enough information to terminate that nurse, we will just destroy documents and create documents under the name of a dead nurse to support that nefarious conduct. It is hard to imagine a case that screams out more for the at-will employment exception in this case. We have two general propositions. First, there is a claim under the Public Health Code in this situation for violation of public policy. But it's not only the Public Health Code. The public policy is enunciated in the rules of professional conduct for nurses, the administrative code that licenses nurses in the state of Michigan, the Constitution as well. Second, the Whistleblower Protection Act cannot be the exclusive remedy in this case because it provided no remedy. And the defendant's, Mr. Warren's discussion regarding Dudowitz is absurd. Dudowitz only did not apply because he reported to a prosecutor in that case, and therefore he had a Whistleblower Protection Act case. You can't convert a whistleblower case into a public policy case. They've suggested to you that this was voluntary. Nonsense. It was not voluntary. He was not a whistleblower, as that term is defined. Had he come to me then, and had I filed the claim, he would have had no protection because he did not report or threaten to report to a public body. But number two, the suggestion from Mr. Warren that this was, quote, voluntary is nonsense, because as I put in my brief, it's reminiscent of the Salem witch trials. There is no redemption. Under the provisions of section 2180 sub 4, he had to give written notice. He had to wait 60 days before he could report to a public body. He had to get a written response before he could go to a public body, and they preemptively terminated him so he could not be the whistleblower the statute believed. So if you believe the legislature created this act to prohibit the retaliatory discharge of an employee, a nurse, but then they're not going to say that, gee, oh, by the way, if they fire him before he can become a whistleblower, they're absolved of liability. That, to me, is an absurd result. Statutes are to be construed to avoid absurd results. The defendant in this case exercised the most heinous conduct I have seen in over 30 years of practice. They want this court to stay, contrary to the rulings of every other court in this country, as far as I can tell, that we are going to say it is okay to retaliatory discharge people who report gross malpractice. And I got to tell you, on a dry record, I know just from sitting as a mediator, I've never been a judge, but you can't tell what really went on. If you could see the looks of the bailiff, of the court reporters, of the jurors, of the judge.
Are you of the opinion that we're a jury?
Excuse me?
Are you of the opinion that we're a jury?
No, I'm not.
Those aren't legal issues, are they?
Well, the question is, Your Honors, what I was trying to get at is the incompetence of this nurse was so extreme.
Okay, you'd agree that if we can find a statutory remedy, then you can't employ social duty and you've got a problem, right?
Could you please repeat the question?
If there's a statutory remedy for your plaintiff, we cannot employ social duty and do a public policy remedy for your plaintiff. You'd agree with that very basic premise, right?
Yes, if he had a whistleblower claim.
So the Public Health Code in 333-20180 makes reference to the Whistleblower Protection Act, right?
It does.
That reference that the legislature put in would not be necessary in this case if the plaintiff, your client, actually made a report to a public body, right?
He could not.
No, but I'm not saying whether he should have or could have, or if the plaintiff made a claim to a public body, there'd be no purpose to the legislative statement in here that you have a claim under the Whistleblower Protection Act, because the Whistleblower Protection Act, standing on its own, would provide that claim, right?
That's true, but what I anticipate.
So why does the legislature put this in 80? And I ask that question with the note that before it references the Whistleblowers Protection Act, it says an employee may make a, quote, report or complaint, including but not limited to a report or complaint of a violation of this article, the Public Health Code. And then goes on to say, and you'll have a remedy under the Whistleblower Protection Act. Is it possible? Is it possible that the legislature was saying that under this very limited scenario, we're going to expand the WPA greater than what it says on its own in the four corners of that act?
What I believe the reason is that it's in there is to show that there is a private right of action under this specific provision that legislatively states that it is illegal to retaliate against a professional health person who reports malpractice. Other cases prior,
So it refers to I want to just make sure I understand. It refers to the WPA, not because it wants to say there's a claim under the WPA. It refers to the WPA to signal us something else, a private right of action?
it signals that an individual who follows the provisions, who gives written notice, who then waits 60 days and gets a response, who gets a written letter, and then files with a public body, has a private right of action in distinction to prior decisions that had said there is no independent right of action. So in this portion of the Public Health Code, the legislature made clear that a person who is retaliated against would have a private right of action, but it would be enforceable under the Whistleblower Protection Act. In due to which, if that existed, Mr. Landin would have no claim. That is, if he was allowed to become a whistleblower and he then filed with the public body, he would have no claim here. He did not report to a public body, and he was terminated before he could, clearly undermining the goal of the legislature is...
Excuse me, counsel, I'm interested in that, in your claim that your client could not become a whistleblower because he was fired first. And so I'm looking at 15.362, Section 2 of the Whistleblower Protection Act, and it says, an employer shall not discharge, threaten, or otherwise discriminate against an employee because the employee reports or is about to report.
True.
So if he had alleged, hey, I was about to go report, but then they fired me, he would have a claim, right?
No, he wouldn't.
Why not?
Because under 3332180, to get specific you have no private right of action under the Public Health Code generally. 2180 says these are the conditions, if and only if you meet all these conditions.
Right.
No, that's for immunity. That's for the limitation you have that you're referring to, that you have to wait 60 days, only refers to immunity conferred by this section. It does not prohibit somebody otherwise from reporting to the department an infraction that is prohibited by this section.
He is supposed to wait 60 days.
I know, for the immunity.
Right.
But he doesn't have to in order to receive protection under the WPA.
But if he doesn't report in conformity with the internal mechanisms of what the hospital tells you to do to go through that reporting process, he is then not a whistleblower.
No, not under the Whistleblowers Act he is.
He didn't report, he didn't threaten to report.
If you're saying, look, the statute says he can't report to the department unless he waits 60 days for the internal administrative process of the hospital to respond to the complaint, correct?
Correct.
That's an immunity provision.
Okay.
That does not preclude, as I understand it, an employee who observes negligence from going to the department directly and saying, hey guys, my colleague just committed deadly malpractice. If you do that without waiting, you may not get the immunity and the presumptions of this section, but you definitely are a whistleblower at that point, are you not?
You may well be, but that didn't
tell me,
happen in this case.
in what way aren't you? If department is a public body, correct? Correct?
Sure.
So if I go to that department the day of the negligence and say, hey guys, my colleague just committed deadly malpractice, I have satisfied all of the elements of the Whistleblower Protection Act, correct?
I can certainly foresee a defendant who would argue, if you don't follow the rules regarding 2180, to wait to report that you have given up any private right of action under the Whistleblower Protection Act. More importantly...
I'd like you to explain that, because I think I've just outlined a scenario where you have now protected yourself under the Whistleblower Protection Act. You may not be entitled to immunity under the 2180, but you are protected by the Whistleblower Protection Act at that point, correct?
In all due respect, I don't necessarily agree, but the facts of this case, he did not report or threaten to report as he was instructed to do.
But my point is, the fact that your client chose to do something or not, I'm trying to figure out what the implication is. If there is a remedy that the legislature has provided, the fact that your client did not or chose not or didn't think he had the right to do it, is that what's dispositive of determining whether there is a remedy, such that Such-Odusky does or does not apply?
And due to which, that's exactly what the court said. Because he went to the prosecutor, he had a right. The other case that's very interesting is Driver, if I remember it, and it's a Court of Appeals case, and I believe the facts in Driver, and I hope I'm correct, but what happened was, initially, they said Driver had a Whistleblower Protection Act claim. They dismissed the public policy claim. On appeal, it got reversed, so there was no Whistleblower Protection Act claim. That reignited the public policy claim. Because he did not have a Whistleblower Protection Act claim, he then, of course, had a public policy claim because he didn't have a remedy. The cases are legion. An exclusive remedy cannot be a remedy if it provides no remedy.
Can I ask you my Elliot Larson hypothetical? So, it's the same one that I posed to the appellant. So, if we have a person who is fired because of race, clear violation of the Elliot Larson Act, and waits until the statute of limitations is expired, and then files the claim, the court will dismiss it because the statute has run. Can they now bring a claim, a wrongful discharge claim, because the well-established public policy is against race discrimination?
Of course not.
So why is your case different than that case?
Because
Here,
the
the
person
person
had
didn't avail himself of the remedy by going to the public health department. In my case, the person didn't avail himself of the remedy by timely filing his lawsuit. Why are those different?
Well, they're different because the Elliot Larson Civil Rights Act gives you a specific remedy. In this case, there is no requirement under the Public Health Code that you report to a public body that there is wrongdoing. It says may, number one.
There's no requirement
number
that
two.
you sue anybody. Even if
Excuse
you've
me?
been, there's no obligation to sue anybody, even if you've been discriminated on the basis of your race.
It's just if you want a remedy, you have to do it within 3 years. You can't wait for 3 years and a day.
And you have to meet the other prima facie aspects of
Sure,
that
of course.
case. In this case, he was not a whistleblower. He never threatened to report or to report. What the court is saying is that in Tyrion, a case the defendants sort of abandoned in their reply brief, which they rely on exclusively in the brief on appeal, the court said that definitive indication that state policy prohibits a discharge of a nurse who reports that another nurse is guilty of malpractice. The Justice Markman in Tyrion said, you look to express legislative statements, not to the whims of individual judges. In this case, 2176 says that under the Public Health Code, you cannot retaliate against an employee who reports malpractice.
Does
That is
2176 require the report to be made to a public body, or is it sufficient that your client reported to his employer under that
Yeah,
subsection?
it doesn't say anything about reporting to a public body in 76.
And just so I'm clear, I think we all are, but there's no facts in this case that your client reported to a public body. I think we all know that.
Yes.
But there's also no facts that he was about to report to a public body and that his employer somehow knew that. In other words, he can't just allege in the complaint that it's in his mind this is something he was about to do. There has to be some causal connection, which would require evidence that the employer knew of that, right?
Yeah, in the record was clear. Nobody said he threatened to report, so.
And so I mean, I guess again, in response to Justice Larson's question about the Elliot Larson Act, isn't the answer that to her hypothetical is that we're dealing with a different situation where the act doesn't encompass the facts that are alleged to have occurred in this case. So it would be more apt to say something like, instead of saying the statute of limitations is passed, it's the Elliot Larson doesn't cover, instead of skin color, maybe hair color. If you had a hair color claim somehow under some statute, you're just in a different environment than you would be if you had a claim that fit squarely under an existing act.
And there needs to be a compelling underlying legislative statement that is not otherwise addressed that gives you another remedy.
Just a minute. It's been hypothesized that the conduct here was more analogous to hair color, which is not a protected characteristic under Elliot Larson, than it is to skin color. My question, therefore, is, other than the intent of your client to report in one way versus another, why isn't that Whistleblower Protection Act remedy available? In what way, other than your client's intent not to exercise that right, in what way was it not available to him, had he chosen to do it?
Had he chosen to do it and violate what he is told internally in the hospital to report through the chain of command, which the legislative history of 80 shows that that was the hospital's intent in putting the 60 days in there, so that a person,
Yeah, but
before they
just
would
an
go to a
Just
public
a
body.
moment, an employer cannot preclude a person from exercising rights conferred by the WPA, right?
Well,
Do you believe that?
I believe that as an employee, I can do whatever I choose to do. The employer cannot physically stop me from doing something.
Not legally either.
Right.
Okay. So, this is a framing question. Justice Viviano proposes that, is the remedy available if it wasn't exercised? I'm asking the question, does the fact that the person didn't exercise it, but it existed and could have been exercised had they chosen to do so, does that make it less available than had he done so?
With all due respect, we differed somewhat with the opinion of whether that remedy was available in light of Section 180.
If Section 180 does not contravene the right of an employee to exercise rights under the WPA, let's put that aside, isn't it clear that your client could have exercised, chose not to, but could have exercised his WPA right to complain to a public official body?
That would be no different, Your Honor, if the person says it's a race or age case, and can I still go report some wrongdoing to a public body? I still could, but I still have my other remedy. In this case, because he went through the proper channels, he did not report, he did not threaten to
I
report.
understand. This is really the question I'm trying to struggle with, and I hope that you can help me. The question is, what's available? When is a remedy available? Is it unavailable if I choose not to exercise it, or is it unavailable if under no circumstances it was available to me?
In this case, Your Honor, I think what the court needs to look to, whether this termination runs contrary to specific legislation, is this court held in Sukadolski, is this court held in Tarian? And in those cases, you look to the underlying policy. The reason for the termination in this case is heinous. It is against any civilized society.
Regardless of whether it's heinous, doesn't the WPA claim require a different factual predicate than the one that you've alleged and proved in this case before a jury?
Absolutely. It's a totally different predicate, and moreover...
Let's be specific, because what I'm focused on, and I'd like you to address, is the causation and the retaliation, I think, that you've alleged in this case is that your client was fired for reporting to his employer. Is that accurate?
That's absolutely correct.
So even if your client reported or was about to report to a public body, we don't yet know, it's unknown, it's hypothetical, or it would be a hypothetical statement at this point to say whether his employer would have fired him because he reported to a public body. We don't know that, right?
We don't.
And so I think that's the specific factual difference that at least that I'm focused on.
I think that's what's troubling me too, and I don't know that I'm going to be able to articulate it well, but the concern I have here is that the discharge obviously occurred before the report of the discharge, thus calling into question whether or not the causational requirement of the Whistleblowers Protection Act applies here in a very traditional way. And the initial report was a report of malpractice. It wasn't a report of a violation of the public health code. Malpractice, as far as I understand it, is not such a violation. So it seems to me that we're kind of turning topsy-turvy you know, the whole premises of the Whistleblower Protection Act, and maybe you're saying it, but it's not clear to me how you view that situation, the causation argument.
Well, as the Court of Appeals stated in its unanimous opinion, all Mr. Landin was doing was reporting malpractice. He was reporting it as his advocacy
Which is
role.
not a violation per se of the Public Health Code, is that right?
Correct.
Could he have reported the exact same actions here as a violation of the Public Health Code?
I believe, and I know Justice Young and I went back and forth, I believe that if a plaintiff did that, they would have real trouble going through.
Because of the procedural mechanism. But
Exactly.
I just mean the underlying actions that were taken at the nursing home. Are they a violation of the Public Health Code? The malpractice at issue here would also be a violation of the Public Health Code?
I
Yes or
don't
no?
know. I don't know whether that is akin to the do to which, where you go to the prosecutor and make a claim. If you go to a public body and make a legitimate claim, well, then you would be covered under the Whistleblower Protection Act. In this case, Mr. Landin was reporting malpractice through the normal course and channels as he was instructed to do.
Indeed, I think my concern is even more fundamental about Sue Shuldowski. Is it really fair to describe Sue Shuldowski, as we typically do, myself included, as creating a public policy remedy, particularly the first prong, where the first prong explicitly references legislative statements that seem to prohibit a discharge? And if you look at what occurred in that context in light of a decision of this court, the Lash decision, you apply the four-part test in Lash, you attach it to the circumstances that occurred here, and Lash says you can presume that a cause of action could be created to redress a statutory violation when the four prongs of Lash are satisfied. First prong, to protect a class of persons, which includes the one whose interest has been invaded. At least arguably that applies here. To protect the particular interest which is invaded, to protect that interest against the kind of harm which has resulted, the termination, I suppose, and to protect that interest against the particular hazard from which the harm results. Why, if you put together the explicit legislative provision prohibiting a discharge under this circumstance in light of Lash, do you have something that's very far removed from being a mere public policy exception, but in essence is, for all purposes, tantamount to a statutory exception?
Well, I believe, Your Honor, if you look at all the different statements in the Public Health Code, the Constitution, the Administrative Code that says the licensing and regulation of nurses is to preserve, protect, and improve the health of the public, those things, in conjunction with Sue Shuldowski, a termination under those circumstances runs contrary to voluminous legislative statements that are clearly, and as the court said in Tarian, you look at actual legislative indicia, statements made by legislatures. The Public Health Code is to be liberally construed, not a judicial mandate, a legislative mandate. In considering those things, I would suggest to you, Your Honors, that in this case, that in a civilized society, this type of conduct cannot be allowed. And I cite 6 different states.
Could I ask you to follow up on Justice Martin's question? Lash is an implied remedy case, correct?
I don't remember the specific facts of Lash.
Okay. As I understand our jurisprudence in implied remedies, our goal is not to freewheel determine when remedies should be availed. As I understand it, our goal is to try and understand what the legislature intended, even though it didn't make an explicit civil remedy. Would you agree with that as the theoretical jurisprudential inquiry in implying a civil remedy where none is specified?
You are definitely supposed to undertake the legislative intent and whether there is a legislative statement indicia that the legislature is intended to protect this class of individuals.
But that's clearly not what the inquiry in Central Duske is, correct?
Well, Sukadolski had 3 exceptions that allowed public policy claims. They found in that case where there is an internal dispute among accounting methods, that did not rise to.
I'm trying to figure out, you want to get right down in the weeds. I'm trying to figure out what the doctrinal issues are here. In Lash, we try and figure out, we have a catechism that we use to try and deduce what the legislature probably intended, even though it didn't provide a civil remedy, in determining whether we should find one. It seems to me Central Duske does not operate in that framework at all. Is that accurate? We're not concerned about whether the legislature truly intended a civil remedy. It's something different, right?
Well, in Sukadolski, if it runs contrary to a specific piece of legislation, a public policy action can be inferred. And clearly, in this case, there are numerous pieces of legislative statements
All
that
right, now,
suggest.
Are you then suggesting that Social Duske can be reconciled with cases like Lash? It's just another method of implying a civil remedy?
I don't remember Lash. I definitely remember Tarian, and Tarian, I think, is perfectly consistent with Sukadolski and consistent with this case.
Can I drag you back into the weeds? I know you,
Okay, sorry.
just for 1 second.
That's where she
Just-
lives.
I want, yeah, I just
I live
want
in
to
the
hear your
weeds.
answer to one question in the weeds. Assume I agree with you, and I'm not saying I do. Assume I agree with you that he had to wait the 60 days before he could file a complaint with the public body. He was fired on day 63 after his internal complaint to the hospital. Is that correct?
He was fired. I believe he actually was suspended on April 23rd.
But he doesn't have a
and
cause of action for suspension, does he? I mean,
No.
right. So he was fired on day 63. Why didn't he have some obligation on day 61 or 62 to complain to a public body, even if I were to agree with you that he couldn't have done it in the first 60 days?
Well, he hadn't received a letter back
Well,
from the
or
hospital.
he had to have no reasonable expectation that the hospital had taken or would take timely action, which you might have if 60 days has passed and the hospital hasn't taken it, right?
Until he's notified that he's being terminated on the 28th, he doesn't know he's going to be terminated.
Okay.
So I guess that would be the answer.
That's good. That's all. Thank you.
All right.
Appreciate the
Thank
I
you
time.
see
very
my
much.
time is up, Your Honors. It's always a privilege to be here. Thank you so much.
Thank you.
May it please the court, I'll be brief. I do want to go back to this prima facie-driven analysis and just emphasize that there is no prior decision, nor is there any legislative statement that says the court should be undertaking a prima facie-focused analysis to determine whether a remedy exists, period. There's nothing that says that we can do that. And if we do, the road we will go down is what Justice Larson has brought up twice. We could have an Elliott Larson Civil Rights Act claimant who says, I am an independent contractor. I am not an employee. Therefore, I have no cause of action under Elliott Larson. I was discriminated against because of my race. The Elliott Larson Civil Rights Act espouses a principle against discrimination in the workplace setting. Therefore, I have a prong 3 Shadolski claim.
Counsel, I have a question though. And I'd like you to respond to Brother Counsel's assertion that how can you have an exclusive remedy if it is not a remedy? If you could just respond to that, I'd be interested to hear your answer.
I can respond, Justice, and I think my response is that the fact that someone can't prove a prima facie example under that remedy does not mean the remedy provided by the legislature suddenly blinks out of existence. It still exists, it's still there, and under Dudowitz, it's determinative of whether there can be a viable public policy claim. And the answer is it can't. And the last point I'll leave you with is that if the court is troubled with reconciling doctrinal law versus what Shadolski says, this court obviously has the power to limit or contain or pare back or overrule Shadolski.
So I'm going to ask you the same question I asked your opposing counsel. In the Public Health Code, MCL 333-20180, it makes reference to the Whistleblower Protection Act. You would agree if the plaintiff actually made a complaint to a public body, there's no reason to reference the Whistleblower Protection Act, because standing alone, that act would give the plaintiff a cause of action, right?
I would agree, yes, it's incorporated.
Why is the legislature referencing this? And when read in total, why does the legislature say an employee may make a report or complaint, including but not limited to a report or complaint of a violation of this article or a rule promulgated under this article, an employee who assists in originating, investigating, or preparing a report? Goes through all of these things, then says that employee is protected under the Whistleblowers Protection Act. Why would they say that?
And I believe the answer is because the legislature intended to encourage public reports.
Or did they expand it?
Is it possible that as it relates to this particular aspect of the public health code, what the legislature was doing is saying, under these circumstances, we're going to expand the WPA. You have a remedy under the WPA.
For initiating a report under this article.
And I agree that the legislature intended to provide a remedy under the WPA.
Is there a rule of statutory interpretation or construction that would bar us from reading these two things together in that way?
I don't think you've acknowledged the point. Is this reducing some of the restrictions of the WPA by permitting a report made under this article as opposed to a public body?
I believe it is. I believe it is affording people in this class access.
Broader rights under the WPA than the freestanding?
Than someone who's not under the public health code.
Correct.
Sorry, I didn't.
That's the question I have. I don't know the answer.
Anything else?
Nothing further.
Thank you very much.
Thank you, Your
The
Honor.
case is submitted.